Actually, I have a story. Maybe I can just start off. I had a broker of record call me this morning, and what had happened was one of his new agents, she was literally just licensed 3 weeks. She had shown a listing for lease that the brokerage had to a potential prospective tenant. And the prospective tenant provided her with the information such as, an offer for employment, some other paperwork. And without even consulting the senior agent who was the listing agent, or calling her broker of record, or even discussing with her client, she went ahead and rejected that prospective tenant. And she said in her email to that prospective tenant, she said, as discussed with my client, we are not going to be proceeding with your application. And this prospective tenants, so two of whom were women of color, one was a gentleman of color, they had raised the issue of a human rights violation, because they now feel that since no reason was given as to why their application was not accepted or rejected, that the only reason could be because they are minorities. So when the broker of record called me today, and he said, this is serious, because the new agents should not be even rejecting applications without consulting not only the broker of record, but the listing agents. So please be careful if you're working on a deal and on behalf of another agent, and it's not even your listing, make sure you're always truthful to your client. Because if your client doesn't know what's going on, which in this case, the landlord had no idea that the application was rejected by this new agent, and now they're going to be slammed with a human rights violation, it doesn't really look good. And it's not only a human rights violation, it's a RICO complaint. So just be really careful of how you're letting down prospective tenants. Make sure if you're new in the business that you engage in contacting your manager or someone that has the experience that you don't have.
Is it our right as an agent to ask potential tenants to give us a rental application before we show the property to them?
I mean, you can ask them. Do they have to provide it? Probably not.
Some people
that a lot of agents don't want to just go to a property and show it to people to prospects that are unqualified, correct?
Of course, because sometimes it's a lot of them, and many of them, they are not qualified. Another, and usually if they reject to give me a field rental application, I ask them to tell me about themselves a bit. And then if they just say something useful, which is job and the credit, okay, that's good. If not, I, in continuous, like asking more questions, I ask them, how are you doing for your living? Or what is the source of income that you told everyone that asked for source of income first.
You got it.
And also in continuous, I ask, how's your credit? And then when they say their credit is not good, I tell them, I know my client, this landlord client of mine, he has really issue with credit. Before, he trusted some people with bad credit, and he had a very bad experience. That's why he's like very concerned about the credit. Is that okay to tell them like this?
Yeah, absolutely. I mean, your credit is the only thing that a prospective tenant can show a landlord that they have the ability or credibility to make their monthly payments. Right? So always get a detailed credit report. And
yes,
Yeah, you're right. That the questions that you are asking, even though you don't have a physical rental application or letter of employment, the questions you are asking kind of gives you an idea as to how much the person has as a source of income. Like, for example, if they're a teacher or a nurse, you kind of have a rough idea as to how much they make,
Sure, yes.
right? So the questions you're asking are great. Continue asking these questions.
Okay, that's good. Good to know, because sometimes I remember before you told us some of the questions is like kind of against human, I don't know, rights and other rights. You had a very good session for us to tell us that what kind of question we shouldn't ask, which I remember it well. But I mean, many people avoiding giving me, despite the fact that I send them my card, that they see that I'm a real estate agent and I'm handling a lot of documents, legal documents of people. But still they say, no, they're not comfortable. Even once I told them, do not put like very like information that I don't really want to, like your what do we call it, SIN number and even ID number. Don't put it there, because I want to know what they do as living, and I want to know where they lived before and why they're moving, and they're all questions in the rental application.
Right.
But still, some of them avoiding to give it to me. No, we wanna see the property first, and then if we like it, we send you the documents. I don't
Right.
know what to do with them.
Yeah, this is the thing. This is why video tours are really good, right? Video tours, if you do video tours, they can, I mean, by looking at the video, they know that whether or not they want the property,
Oh, that's a good point. Thank you.
right? So definitely do video tours. Pictures are a little deceiving because you don't know using what type of a lens can show the property bigger or smaller. But definitely, I mean, I'm a landlord myself, so I use a lot of video tours, and that gives you an idea, or whoever's watching the video, an idea as to what to expect. I mean, if by looking at the video tour, they still want to see it in person, then they're serious. I mean, in my opinion. I don't know why a lot of prospective tenants don't provide paperwork. I never really understood that, but the serious ones will. The tire kickers won't. It's similar to a buyer wanting to look at a property without having a mortgage approval, right? Well, if I like it, then I'll go for financing. Well, it doesn't work that way. People are not going to wait for you to go get your financing. Same way as for a lease, the landlord is not going to wait for you to get your paperwork together. So what I want you to do is when you have prospective tenants, only ask them those qualifying questions that are relevant to the tenancy. Okay, I've put up, I've shared my screen here. I want you to have a look at these. These are questions that realtors cannot ask when advertising a property for lease on the MLS. Okay, and the reason is because none of these questions are relevant to a tenancy. Okay, whether or not the person is married, single, divorced, well, what does that have to do with the tenancy? Whether or not they're even a Canadian citizen. I mean, I had a call from an agent over the weekend, and she said that, you know, we're looking at a property, and the landlord has asked us to provide our citizenship paperwork because my clients are not citizens. There's nowhere in the law that says that a tenant has to be a Canadian citizen. It's not relevant to a tenancy. That can open a landlord up to a human rights complaint. So just any question that you're asked or you're thinking of asking, first ask yourself, is it relevant to the tenancy? And if it's not, or if you feel it's not, then it's probably not. If you're on the fence, give me a call or shoot me an email and ask me first.
Question about that item that you said Canadian citizens. I understand that, but you know, what about the status of residency. We know there are some people that are illegal residents in Canada, and they don't have any status.
Yeah, even the illegals need somewhere to live. In fact, sometimes those type of tenants make the best tenants, right? Because they don't want to get into trouble. So they make sure the bills are paid, they make sure the rent is paid, they take care of the property. What I'm saying is that you can't discriminate whether they're illegal, whether they're not illegal. You are not in that position, or your landlord is not in that position. Okay?
Right, but my question exactly is there any, if some illegal residents living in my property, so is that, do I have any responsibility, because maybe government of Canada coming after them, and why you're in Canada, why you're living in Canada? So is that becoming a responsibility for the landlord or not? Just that's it.
It has nothing to do with the landlord.
Okay.
What I mean is that there's nowhere in the law, in the Residential Tenancies Act, that speaks to somebody's status.
Okay. So
Okay.
we don't need to ask about the residency status, about the citizenship, anything.
Correct.
Okay, I have a client who bought a house, and in the basement there is, it's a legal basement, it's a legal duplex. A tenant was in there from long time ago. My client asked me, I don't want this tenant because she pays $1,300 while it's $1,800 right now. I told him that law in Ontario don't let you to ask her for more money unless it's in like regulated amount and on the starting day of tenancy. First of all, he didn't listen to me, and he asked him to leave, and also said that like it's not a real thing, but he said my parents are coming to live there. I told him not to lie to people. Now he's doing that, and this couple are leaving tomorrow, and he wants to rent it to other people. I don't know what to do in this situation. I gave my client all the advice that I knew it's not right to do and it's right to do, but he doesn't listen to me.
Well, unfortunately, sometimes our clients don't listen to us. I mean, it's unfortunate for them that they don't take the advice that you guys as realtors have, and the amount of experience that you have under your belt. I never understood why people never followed the advice of their realtor. Just make sure that your advice to him is in writing so that they can never turn around and say, hey, Faye told me this. Do you know if an N12 was served by your client?
Yes, and he gave them 1 month rent for free.
Okay, so if an N12, what you can do is have your client, let your client know to really read the N12, because the wording in the N12 is very straightforward. Whomever is indicated to move in must move in for at least 1 year. And if they do not, then the tenant has recourse. Okay, and that means that the tenant can bring forward an application on bad faith against the landlord. It's very, very, they really need to understand the N12. Okay, I'm gonna just share my screen for a second. See where it says reason 1? This is the first page of the N12. Okay, reason 1, the following person intends to move into the rental unit and occupy it for at least 1 year. So if the person that the landlord indicates here, okay, does not occupy it, then the tenant can bring forward a bad faith application against the landlord. Moreover, on the second page of the N12, it says, what if you disagree with the notice? Okay, this is to the tenant. You do not have to move out if you disagree with what the landlord has put in this notice. So if the tenant does not move out and they dispute the N12, they have a right to do that. And then the landlord has to file with the board and convince the board that whomever is going to be moving in is actually going to be moving in. Because the N12 alone has no enforcement unless the landlord applies to the board, follows the legal channels, obtains an order for the board, and then enforces an eviction. This is the only way the landlord will be able to evict. Now, using the N12 as a loophole to end the tenancy by kind of trying to squeeze out the tenant, this is a bully tactic. If the board realizes or orders a dismissal of the landlord's application, and then in the future, the landlord says, well, I want to sell the property now, Faye, and the tenant doesn't leave, they still have to go through the process, but now they have to disclose of their previous N12 being served to the tenants. So again, I mean, you can only do so much as an agent. If your clients choose not to follow your advice, then it's up to them. But always make sure your advice is clear and in writing so that they can never turn around and say, you didn't tell me. In fact, what I would do is what I would suggest is to take a screenshot and maybe underline the following person intends to move into the rental unit and occupy it for at least 1 year. Okay, really pay attention to the wording.
Okay. But the new owner of the house cannot raise the tenant, the previous tenant who lives there, on the day of having the property, right? They
Correct.
cannot do it.
They cannot. So if you have a new purchaser that purchases the property and they close and they become the landlord, the only thing that changes is who the rent is paid to. That's it. They can't raise the rent. They can't get the tenants to sign a new lease. They can't do that.
Oh, not even the new lease? I mean,
No.
the new lease with the previous amount?
No.
No. Okay. Then they don't have a lease.
They don't have to have, well, they do have a lease. See, there's a section in the act that says covenants that carry forward with the land. And similar to that of real estate, what was there before is taken over by a new purchaser, covenants that run with the land. Okay, so that means if you are my tenant and we have a lease, and then I turn around and I sell the property to Farshid, and Farshid is now the new landlord, he's basically what he's doing, he's stepping into my shoes and carrying my lease forward, whether it's a fixed term tenancy or whether it's a month-to-month tenancy, because the lease was there prior to Farshid being the new landlord. Does that make sense? It's a covenant that runs with the land.
Yeah, it does. So they have to ask the previous owner to forward them the lease that they have. If they don't have a lease?
If they don't have a lease, then the Residential Tenancies Act takes effect anyways.
Oh, okay.
Okay. But there's one other thing. I'm going to share my screen because I think this is really important. I want to have a discussion with you. You guys can see this now, correct?
Yes.
Okay. So for those of you who haven't followed us on Instagram, head over to our Instagram and follow us, Stonegate Legal Services. we're always, the post that we make is always to educate you and keep you well informed with the law and what a landlord and tenant can do and cannot do. One of the things that is always a topic of discussion is snow removal and lawn
Thank you so
care.
much for watching. If you like our video, please hit the like button,
Okay?
the subscribe,
here's a
and
flow
even the
chart,
little bell
and
to get
this is just to
notifications,
simplify, because,
just so you can
again,
stay in touch
I used to
and
make
watch
the
more
same
of these great
mistake when
videos.
I was drafting leases in my days of being in real estate. And I always thought that if I put it in the lease that the tenant is responsible for snow removal and grass cutting and salting, that I've washed my hands clean and that is the tenant's responsibility. Well, the Residential Tenancies Act says otherwise. The Residential Tenancies Act says that anything in the lease agreement that is contrary to the Residential Tenancies Act or the law is automatically void and unenforceable. Now, I mentioned to you that that clause that I used to put in is that the tenant is responsible for snow removal and lawn care. Well, although the Residential Tenancies Act does not make direct reference to who is responsible for snow removal or lawn care, it does say in section 20, it does say that the landlord is responsible for maintenance. Okay, so lawn care and snow removal fall under maintenance. So anytime, I mean, if you want to take a screenshot of this, feel free to. If you want to go ahead and follow us on our Instagram, you'll find many other flow charts as well that will help you in your business. This particular flow chart starts by asking you, is there a separate maintenance contract for compensation? So in addition to the lease, is there a separate contract saying who's responsible for maintenance with compensation attached to it? If yes, then it's the tenant's responsibility. If no, it goes to further say, is this area part of the rental unit or leased premises? If no, then it's the landlord's responsibility. If yes, then it's then they ask you, is it maintenance? If yes, then it's the landlord's responsibility. Is it ordinary cleanliness? If yes, it's the tenant's duty, responsibility. So this will give you an idea that, I mean, what you should be able to pull out from this flow chart is that a tenant can be made responsible for lawn care and snow removal, provided that there's a separate contractor's agreement that the landlord is contracting out the tenant and paying them compensation for this duty.
But Schedule A is not another contract with them?
No, it has to be a separate contract. It has to be, for example, how would it be if you're contracting a snow removal company? It has to be a separate contract, no ties to the lease. Now, you can find a sample contract. If you go to landlordmastery.ca, you can have access to our Google Drive and download a sample contractor's agreement. And you can fill it in the event that your clients want to put the tenant as, responsible for snow removal or lawn care. Okay, so Ali asked a question. My question is, if it is the first year of tenancy within 12-month lease and the landlord wants to sell, what are the options? So Ali, the landlord can go ahead and list and sell a property with the tenant in there. And only if the new purchaser requires vacant possession for their own use, then the appropriate notice can be served. If the landlord wants to avoid any headaches with the tenant, I always inform that a cash for keys is definitely the best way to get the tenant out before even listing the property.
I'm asking in general, if let's say a landlord decides to make the unit legal, like retrofit it, can they do it while they are there, or what should that landlord do?
They can do it as long as it's not required for the tenants to vacate while they do it. Okay.
And the other question is, for such a tenant that pays all the time, at first it started with sorry 1 day, 2 day, then it's habit, and the tenant is very aggressive about this. So what can be done?
So if it becomes a habit, then a landlord can serve the N8 notice for persistent late payment. Okay? And
Yes,
what that is that gives the tenant 60 days to vacate. If they
Okay.
don't vacate in 60 days, the landlord can apply to the board for a hearing. When the landlord applies to the board for a hearing, the board will issue a pay on time order. And a pay on time order orders the tenant to pay in full and on time for the next consecutive 12 months.
okay.
1 day late or $1 short is an eviction.
So from the time that you give the tenant a form N8 until like you receive response from court, how many days is this?
4 to 6 months.
Meanwhile, so you give the notice to the tenant, they have 2 months, 60 days to leave.
Yeah.
And if they don't leave,
If they don't leave, then the landlord has to file with the board.
for them to go out.
Correct.
And then court decides to send them out, or if they were doing, okay.
The board will issue a pay on time order. The board is not going to evict them. Okay, and a pay on time order is ordering them to pay in full and on time for the next consecutive 12 months.
And if they don't,
If they don't, if they're 1 day late or $1 short, then the landlord can proceed to evict them.
okay. This other question is about bill payment, not bill payment, utility payment.
Okay,
When you make a contract with a new tenant or a tenant in general, and as a part of contract, all bills, utility bills, when they rent the whole place goes under the tenant name. Some of the services such as furnace and air conditioner, if there is such a service purchased prior to the tenant moving in or during that time, and in the contract it says all the utility bills included this and that and not limited to such and such. My expectation is that the tenant has to pay. Am I right?
well, that depends what's in your agreement.
If it's okay, if it says utility payment, but not including limited to this and that, anything in the bill.
Well, just so when it says including but not limited to, it means whatever the bills are, that's what the tenant has to pay.
Yes.
Right?
Yes.
So
Yeah.
if it says that the tenants are responsible for utilities, then yes, they would have to pay for all the utilities.
For the service contract that comes with the utility bills.
Correct.
So my question is pertaining to my question with regards to a first year of tenancy and if the landlord wants to sell. In that situation, you mentioned that that it is doable if the purchaser don't want to move. Basically, they have to assume the tenancy. In that case, you could do it, right?
Correct.
Okay, so you have to specify that this is not for the residential use of the purchaser. They have to assume the tenancy.
Correct. Be very clear. Make sure you're very clear as to what the intentions are of the new purchaser.
Okay, and in terms of the tenant allowing the buyers to come in and visit, as the first 12 months are not over, can he not have resistance to that?
I'm sorry, can he not have?
Is he obliged to allow buyers, even though it's the first 12 months of the lease?
Yeah, you can sell a place even if you're still within the lease terms or lease date. It's just whoever buys it has to honor the lease. So whoever buys it cannot move in until after the lease expires.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.